Before the short adjournment, you kindly looked at paragraphs 14 to 16 of our printed case, which makes our submissions in Article 6.6 of the 2001 order. I said that after lunch I would look at what the respondent to the appeal and the court below said about that. I hope the court hasn't been overcome with suspense, but you'll find what Mr. Lavery says in his printed case about Article 6.6 at paragraphs 32 to 35. You'll find that at MS page 229. Or it's in the core volume. First point that he makes, paragraph 32, is that the 2001 order does not purport to provide an exhaustive list of what periods of time are counted or not counted for tariff expiry purposes. That of course is right, but we say, so what? We say that Article 6.6 makes clear the intention of the statutory scheme. Time which passes does count unless expressly excluded. The next point made in paragraph 32 of my learned friend's case is an analogy with bail. He says that time spent at liberty on bail is analogous to time spent on licence, and that doesn't count towards sentence reduction. We simply say about that, my lady, my lords, that that's a red herring in our submission. The suspect is on bail. They are not generally a sentenced prisoner. They enjoy the presumption of innocence. They might be sentenced, or they might be bailed pending sentence. In a tiny minority of cases, they might be bailed pending appeal after sentence. But generally, someone on bail has not been sentenced, and the time not in custody, and the time should not therefore count towards sentence reduction. But this is a matter of statutory interpretation, and we respectfully also say that the court is not likely to be assisted by analysis of that type. So the learned friend engages really with the text of Article 6.6 in paragraphs 33 and 34, and he picks up here what is said, what little is said about this issue by the divisional court, which I'll take you to in a moment. So paragraph 33, he says, secondly, Article 6.6, as noted by the divisional court, merely replicated its statutory predecessor, section 38.2 of the 1953 Act. Again, that might well be right, but we ask again rhetorically, so what? We say the 2001 order specifically makes provision in relation to life sentences and indeed in relation to the reduction of time towards the service of the tariff portion of life sentences. That's exactly what this case is concerned with, and that we say is highly significant and points to the statutory intention behind the 2001 order. And my learned friend goes on to say in paragraph 33, it doesn't follow from the inclusion of a safeguard for time spent unlawfully at large that all other periods, however they are served, are by necessary implication to be included in the calculation. As to that, we say, well, that is the plain and natural implication of Article 6.6. If the respondent was right, then it would not be needed. The provision of that article that says time spent unlawfully at large should not count would be totally unnecessary. It would be clear, as the court knows, there's a canon of construction that statutory provisions are not to be taken to do so. Now, that chimes with, perhaps I'll just finish that paragraph. At the bottom of page 229, my learned friend goes on to say the article simply provides a mechanism whereby time spent unlawfully at large may be retrospectively taken into account in exceptional circumstances. And then the same point is essentially made in paragraph 35. That takes its lead from the judgment of the court. If members of this court would turn on to MS 269, you will see that the divisional court dealt with this argument, which we below, as here, is towards the centre of our submissions, in a very cursory way. In paragraph 51, where the court essentially deals with a range of arguments made by the parties before the Divisional Court in a sweeping up fashion. But you'll see there at Roman 4, page 269, Article 6.6 does not affect our analysis of the legislative intention elaborated above. That's principally the legislative intention of the 1998 Act. This provision had its advent in the 2001 order and not the 1998 Act. It simply replicates its statutory predecessor, Section 38.2 of the 1953 Act, and in our view is readily explained as being designed to cater for mitigating factors or other exceptional circumstances in the case of an unlawfully at large prisoner. For example, a genuine misunderstanding relating to the terms of temporary release or compelling compassionate individual circumstances. Pause there for a moment. The court does there seem to concede that a period of temporary relief during the tariff period can be deducted from the sentence that can count towards service, which we say is contrary to the court's conclusions elsewhere in its judgment, essentially that during the tariff period, the full period must be served in custody. But in any event, the court says it's designed to deal with a very small category of cases where that arises. The judge continues, the self-evidently elevated threshold engaged by the perversity argument which was raised is manifestly not overcome. Further, the argument that but for Article 6.6, account would have to be taken of a period or periods unlawfully at large does not follow from the statutory language. As to that, we do say it does follow from the statutory language as a matter of obvious and natural implication. And as to the public law principles, which your argument is said not to engage with, I regret, my lady and my lords, that we couldn't follow that portion of the court's reasoning. Because when you look at the section of Wade and Forsyth, which is referred to by the learned judge, you'll find that for your note at MS 1530. It's law which is well known to the court about relevant considerations. It's very difficult to see how it has any purchase or any relevance to the issue under consideration. We make two basic points in relation to all of this. If this provision was simply designed to cater for the very rare case where someone was unlawfully at large and yet that time should count, the legislature could have said so in much more simple and plain terms. They could have said, for instance, in determining for the purpose of this article whether a life prisoner to whom this article applies has served the relevant part of his sentence, time during which he was unlawfully at large shall be taken into account if the department so directs. It hasn't done that. It's taken as its starting point that time would be taken into account without expressly being excluded. So that's the first point that we make. But the second point that we make, which is not with respect grappled with at all by the court below or by my learned friend for the respondent, is that it doesn't explain why there is no provision whatever for taking into account time spent outside custody, or sorry, outside prison lawfully, where there are compelling exceptional reasons. That point just isn't grappled with. So what we have as a result is, if the divisional court is correct, there is provision for the department to direct that time spent unlawfully outside prison can be taken into account, but there is no similar facility, even in an exceptional case, where someone has spent time outside prison lawfully, and in the circumstances of that case, that time ought to be deducted from their time. So for those reasons, we say the points made in our written case at paragraphs 14 to 16 are not properly or persuasively dealt with, either by my learned friend or by the court below. Lords, the 1998 Act, I think on that we're content to adopt the submissions made by my learned friend Merlin. We'll come back to that in reply if necessary. I think you will have seen the key elements of our submissions on the 1998 Act. We say that Section 4.4, which applies to fixed-term prisoners, very clearly shows what the purpose of the statutory scheme is, which is that when someone is released on licence, time for the purposes of sentence expiry or tariff expiry continues to run in their favour. And in our submission, the key issue about the 1998 Act, insofar as the court needs to get involved with the Act at all, is that there is nothing in relation to life prisoners which displaces what Section 4.4 shows to be the clear policy of the Act. The other short point I'll make about this is the court will have seen that the Divisional Court found it to be highly persuasive that someone in the position of my client, where they breached their licence, would obtain what the Divisional Court thought was a double benefit. So they have their time released in the community, and they also then, even if they breach the licence at some later point, can count that time towards sentence or tariff expiry. That was thought to be unthinkable, something which couldn't have been within the intention of Parliament. Now, we disagree with that for the reasons given by my learned friend, Ms Murnaghan. The 1998 Act and the scheme behind it is exceptionally generous. I don't think anyone disputes that. But we also pose this question rhetorically, although hopefully with more than rhetorical force. If it is an unacceptable affront to the 1998 Act for a life sentence prisoner who breaches his licence and thereby abuses the trust which was reposed in him to obtain a double benefit, as the Divisional Court said, why is it also not an affront for a determinate sentence prisoner who breaches their licence similarly in an egregious way to take the same double benefit under Section 4.4? That is a question we submit which is left unanswered by both the Divisional Court and the respondent. My Lords, I have a very short amount of time available to me. I wanted to address three further points. It might be that some of them we can return to in reply. Perhaps I'll
2 minutes.
I'll address one very briefly, my lady. The principle against doubtful penalisation, we say, ought to have led the Divisional Court to decide this case the other way. The Divisional Court, you will have seen from its judgment, has said very clearly and expressly and up front that the issue in this case was not addressed in the statutory codes. That's the 2001 order of the 1998 Act. Therefore, the court had to look for what it called the implied and unexpressed intention. It's paragraph 33. So Justice McCluskey also referred to legislative gaps left in the 1998 Act. That's paragraph 43. We say simply about that, in those circumstances, the prisoner should be given the benefit of the doubt. And we say that's clear from what Benyon says in section 27.1 about this principle and this approach to statutory construction. We dealt with that in our printed case at paragraph 22, MS 208. I would ask the court in your own time to look at the appropriate section of Benyon, which is at MS 1012. We say further about that, this problem is not something which was likely to have been unexpected. When one releases a large swathe of paramilitary prisoners into the community, many of whom we accept have been convicted of heinous crimes and have substantial records for reoffending, it would have been likely within the contemplation of the legislature someone might breach their licence. If it had been thought at that stage that would result in the result which has been found by the Divisional Court, we say what should have been dealt with. And where there are two competing interpretations, one of which results in what we categorise as an additional deprivation of liberty and the other doesn't, in the absence of clear words, as Benyon says, the court should strive to ensure that the prisoner is given the benefit. My Lords, my Lady, I see that time is up, and unless I can be of any further assistance, those are our submissions on the appeal.
It would appear not, Mr. Schofield. Thank you very much indeed. Thank you. Mr. McConkie? Yes, Mr. Lavery.
My Lady, my Lords, I'm going to deal very briefly with the jurisdiction issue, first of all, and then the chiefly Article 6.6, which seems to have gained some traction with the court, and then lastly how the learned trial judge, the Divisional Court, dealt with these issues, and I'll deal with that very briefly. I'm hoping not to use anything like the time available to me, which your Ladyship may appreciate. Now, first of all, on the issue of jurisdiction, we had taken the position in the lower court that this was a divisional, that it was a criminal cause or matter. So it was a reasonable position to take in the light of the case law available at that time, and without the benefit of the Attorney General's unique focus on the original statutory provisions. We take a very pragmatic view. If the court can find a way to deal with this in some fashion, because we are all here, the cases are publicly funded, we would commend that to the court. But I'm not going to put it any further than that. We've identified perhaps the leapfrog provision, and it's in our written submissions, but I anticipate that the court may say, well, nobody asked the divisional court to use those leapfrog provisions, and it might be a stretch asking this court to put itself in the position of the lower court. But if somebody had asked the lower court to exercise its power under Section 12 to leapfrog the case, first of all, it's something that my client would have consented to, because it would have been a reasonable proposition in terms of expedition and the finality of the litigation. But secondly, it would come under the provisions of that this is chiefly a case to do with statutory interpretation, and to remove one layer of appeals would be a pragmatic approach.
I mean, the leapfrog provisions are the same as in England, aren't they?
There is a difference, my lord. The English provisions, as I understand it, have a more general public interest provision, which we don't have.
They've been quite recently amended to expand the circumstances in which leapfrogging is permitted. You're still back with the original version of Section 12, yes. Yes,
but it may well fall into a case that broadly falls within statutory interpretation. And we said this case is about the 1998 Act and the 2001 Order, and what appears or does not appear within those legislative schemes.
Is there anything to stop you applying out of time for a leapfrog on an alternative basis?
I think there are time limits for a leapfrog. I think it has to be done immediately after the court gives judgment, so I think that may prevent us, my lord. It's not our appeal in any event. We're simply a respondent to it, so it sits somewhat uncomfortably. We could take...
No, I was just wondering, yes. Again, another optimistic thought. You could perhaps delay our judgment for a couple of weeks or so to enable people to go back and get a certificate.
It's clearly something which didn't find favour with the two appellants, my lord, for whatever reason. We've included in our submissions about the jurisdiction issue. So, as I say, I put that before the court, but I can see the limitations of it. Would urge the court to, if there was a way, to deal with the substantive issue. But the corollary of that is that if the court isn't going to deal with the substantive issue, I would urge the court not to proffer any view at all about the substantive issues. If they're ultimately going to be something which is dealt with by the Northern Ireland Court of Appeal, then it would not be appropriate, in my respectful submission, for this court to deal with that. Following on from that then, my lady, my lords, I'm going to make, and this may be because I'm reading the mood music to some extent about the jurisdiction issue, but I'm going to keep my submissions about the substantive issue short. And the first point to make really is that it seems to be agreed between all of the parties that the 1998 scheme is an extraordinary scheme, and that it should, for those reasons, be construed very strictly, and that the ordinary provisions which apply to offences, which are set in the 2001 order, should be deemed to apply unless there's some specific provision within the 1998 scheme which demonstrates otherwise. So without a clear provision indicating that there would be some kind of credit given for a period of time spent on release, that credit could count towards the custodial tariff part of your system. In the absence of that, this should be construed strictly. And of course, there's a tension between that approach of strict construction of this exceptional provision and the normal doubtful penalisation maxims of interpretation. But we say in this case, that this is such a difficult and almost outrageous departure from normal criminal justice provisions that the strict construction of the 1998 provisions should always trump over any kind of maximum of construction dealing with doubtful penalisation. The second part of that as well is there an extra element of penalisation? We say, of course, that there isn't. What one did have, what this prisoner had during the period of 6 years, was release. It was release under the terms of the 1998 scheme, which is much looser in terms of the conditions which will apply to that release. Under ordinary release provisions on licence, strict conditions will be attached. So there would be a more onerous period of time spent on release. This period of 6 years, as I say, should not be taken to be deducted from the 30-year tariff. Now, the 1998 scheme, it's been suggested, was not reflected or would have been in the minds of the legislator when Article 6.6 of the 2001 order was looked at. But, of course, what we say is that one can trace this right the way back to the 1953 Prison Act and to Section 38.2 of that, which is expressed in very similar terms. So the 1998 Act, I can give the court the reference to that, and maybe I'll come to that in a moment. But the 1998 Act chose not to deal with that similar provision in Section 53.2. And we say that's significant. And the 2001 order then simply replicated that. There are a number of points then about Article 6.6. First of all, it doesn't deal with prisoners who are lawfully at large, which would be the case of the 6 years of this prisoner, because he was lawfully released under the 1998 scheme. It only deals with prisoners who are unlawfully at large. So what the appellants in this case are trying to do is trying to imply into a provision which doesn't specifically deal with prisoners who are lawfully at large, a meaning which the provision is not designed to deal with. If you apply ordinary criminal justice provisions, a period at large cannot count towards the detention part of your sentence. The points arise then, what about a period of temporary release prior to a pre-release scheme or other short period of release? And they may or may not count towards the tariff part of your sentence. But that's not an issue which was decided by the divisional court. It's not an issue which is before this court. I understand that it may assist the court in terms of trying to interpret the provisions which are available, but it's one would need to look at those schemes themselves. So the answer is they may or may not count. We don't have a definitive answer to that. So one cannot rely on those and say, well, section whatever says that that period of time may be deducted from the tariff part of your sentence. It's suggested by Ms. Murnaghan that it must, and it would be a disincentive otherwise for a prisoner to avail of a period of day release, because then there would simply be an extra day added to their tariff. Now, my respectful submission, something like an extra day would have a minimal impact on somebody who may want to avail of a pre-release scheme. One is dealing with very short periods of time, not a 6-year period. And that was dealt with by the Divisional Court at paragraphs 35 and 49. The court said, well, it might count, might not. So the court cannot, in my respectful submission, draw any kind of benefit from looking at that. Now, where we say the Article 6.6 provision, coming back to that, we say is a provision which is designed to give credit in specific circumstances, in exceptional circumstances, to somebody who may have been unlawfully at large. And it does not go beyond that. It's a stretch to interpret it beyond that. And as Mr. Schofield went through our written submission, so I'll not repeat all of them to the court, but we say that the 2001 order does not provide an exhaustive account of what periods may or may not count towards the tariff part of your sentence. Doesn't deal with, for instance, time in remand or bail. We say then that the court did deal with this quite fully in paragraph 51(4) of the written judgment, which is at MS 269, which Mr. Schofield took the court to. And the court references Article 6.6 and states that it simply replicates its statutory predecessor, Section 38.2, which, as I said, predates the 1998 Act. And in our view, is readily explained as being designed to cater for compelling mitigating features or other exceptional circumstances in the case of an unlawfully at large prisoner. For example, a genuine misunderstanding relating to the terms of temporary release or compelling compassionate individual circumstances. And that is what the provision is designed to deal with. One cannot take that provision and say that there is a much wider basis for time to be deducted from the tariff element of your sentence. That would be perverse. Now, there were some other arguments raised in the course of submissions. Article 6.6 seemed to be the main argument deployed by both appellants. There were some other arguments that I'd just like to deal with briefly. Perhaps we could turn to the 1998 Act itself, which begins at MS 740, and What is clear from the 1998 Act is that Section 4 of the Act, which begins at 742 and goes into 743, at subparagraph 4, does make provision for some commuting of the sentence in the case of fixed-term prisoners. Now, we say there's a world of difference, and I'll come to this in the judgment of the court between a fixed-term prisoner and a life sentence prisoner. There's a very clear demarcation between the term of custodial, the term of a custodial sentence, and a term spent on licence. And it's significant, we say, at Section 6, when life prisoners are dealt with in a completely separate provision, that there is no indication that there should be any relief in terms of time spent on licence, that should be deducted from your custodial sentence. And in most ways, we say that simply defies logic and any kind of common sense approach to a custodial part of your sentence, to say that you could somehow serve a custodial part of your sentence on licence. Well, they aren't the same, and there aren't any circumstances in which a licence could ever be deducted from that.
But Mr. Lavery, if Section 4.4 does mean that a fixed-term prisoner is continuing to serve his sentence even when he's released on licence, why shouldn't that analysis be applied to the life prisoner on licence?
Well, there are two very different concepts. First of all, the provision at 4 relates to references time spent, time when he could have been discharged on the ground of good conduct under prison rules. Of course, that doesn't apply to a life sentence prisoner. And the very obvious difference is that a life sentence is for life. And there isn't this traditional that you will discharge, again, coming back to the good conduct point. It's not at the discretion of a governor or of the Secretary of State. It relates right the way back to the sentence imposed by the court, or in this instance, retrospectively imposed by the court. And of course, that's significant as well in this context, that the decision of the Lord Chief Justice imposing the tariff of 30 years was given in 2013. And the decision, that written ruling appears in the core volume. At yes,
is it 349?
349, thank you, my lord. And he makes no reference whatsoever to the any deduction of the 30 years of the period spent on licence. Now, that period on licence had already taken place at that stage. So this is a clear indication from the judge setting the tariff that it shall be 30 years. And just on that point, nowhere in any piece of legislation does it indicate that 30 years begins on the day that you are sentenced and then runs chronologically to the end of that period. That would not be a tariff necessarily of a custodial sentence. That couldn't take into account, for instance, time spent unlawfully at large. It's common case that any time spent unlawfully at large, unless directed otherwise, Article 6.6, by the Department of Justice will not count towards the 30 years. So this idea that it simply runs from 1989 to 2019 without break does not follow the logic of the ordinary criminal justice scheme. It's interesting so that the Lord Chief Justice does not take that into account and does not say that, of course, he will get benefit from that. It's interesting as well, and I just want to briefly bring the court to it, what he does say about the breach by this prisoner. It was a particularly egregious breach. He received 16 years in prison. It's not something that the court dealt with lightly or that people should take lightly. This was a threat to the peace process. And he says in paragraph 18.
Sorry, which page are we on now?
MS 355. This is the tariff setting decision of the Lord Chief Justice in 2013. He says at paragraph 18, in this case the killings were professional. Stone offered his services as a killer to any loyalist paramilitary group who would use them. And towards the end of that paragraph, the fact that multiple murders occurred was intended to strike fear into the community at large. It is also an aggravating factor of this aspect of the case that Stone sought to justify his conduct in taking the law into his own hands. And then just lastly, the last 5 lines on page 356, there are serious aggravating factors. The effect on victims will live with them forever. This is a very serious case in which a substantial upward adjustment of the minimum period must be made. The learned trial judge recommended a minimum term of 30 years before he should be considered for release, and I agree. The appropriate minimum term in this case should be 30 years.
But this is all aimed at arriving at the period of 30 years, which was, of course, the recommendation that the original trial judge had made, no doubt for very, very similar reasons. He doesn't mention what that means in terms of a date.
Yes.
He does mention that there was a period on 1998 Act licence, but he doesn't comment what effect that would have. So it's completely neutral as to the point that we've got in front of us, isn't it?
Well, one would have, well, if one adopts our approach, which is that this is absolute common sense, and then we'd say it's not neutral, and this is a common sense view that the Lord Chief Justice took.
He's taking a view of what the appropriate tariff is.
Yes.
He's not giving a date as to when that tariff expires.
No.
At all.
But then...
and he's not discussing the point that we're discussing.
Well, it's not set out in the judgment. I accept that. But I said he could have. The point goes as far as that and no further. But what on the next page is the certificate of opinion from the Licensing and Legislation branch, page MS 357, where it does specifically refer to the time spent in custody on remand, the last line of that. And what we say is that the position of the department and the confusion has arisen because of a decision in the case of Brady. And the pre-action correspondence from the department at MS 309 specifically references page 310, the basis for their position that period on licence should be deducted as this decision in Brady. And this is about halfway through the page on page 310. It appears from the applicant's PAP letter that it goes on, the last line. In that regard, the applicant is referred to the comments of CARE LCJ and the authority of R.V. Brady. And this is something which hasn't featured in the appellant's arguments today at all. It was dealt with by the divisional court, where the court remarked upon the muted reliance upon that case. And perhaps this might be a convenient time to turn to the decision of the divisional court at MS 240. And if I could ask the court to turn to MS 256 while I find the 270 MS, the court, and it's summing up its answer to the arguments raised by the appellants at Roman numeral 9, refers to the ultimately muted reliance on an isolated part of the tariff determination of Lord Chief Justice Kieran R.V. Brady is, in our estimation, of no avail to the Department or Mr. Stone, and that is, the decision itself is at MS 310, but I'm not going to turn it up to the court. That's the relevant extract. The prisoner's licence was suspended. He was returned to custody. He's now served 16 years, 5 months of his licence. Life sentence, a period of 5 years during which he was at liberty on licence under the 98 Act is not deductible from this period for the purposes of calculating his release date once the minimum term is fixed. So that is what the department were relying upon. And the court deals with that just below. This passage, in our view, ambiguous, does not appear to have been the product of adversarial argument, was not necessary for the decision being made, is not contained in a conventional judgment, and was plainly not designed or intended to be an authoritative statement of the law. In summary, it lacks the essential trappings of a binding precedent judicial decision. It is significant it's not been relied upon by any party before the court today. We say this is where the confusion has arisen, and the department standing by its original decision that the period on licence should count, but that any common sense view of this is that if you're given 30 years, you should serve your 30 years. If you don't comply with your part of the arrangement, then one goes back to square one. Why would it be any other way? The court then deals with this MS 261 in the section dealing with resolution. I'm just going to quickly go through relevant portions of from this part on. Resolution begins in paragraph 33. The end of paragraph 33, about 4 lines up, give in effect to what we consider to be elementary principle, the court has embarked upon an extensive examination of pre-enacting history. And in paragraph 34, they describe the tariff. The tariff or minimum term, penal element or actual term, phrase belongs exclusively to the realm of life sentences. And further on down that sentence, punishment has 2 components. One guaranteed and concrete, the other more elusive. The first component consists of the period during which the convicted person must be imprisoned in order to reflect the requirements of retribution and deterrence. And again, if I'm not simply repeating myself, a period on licence cannot meet the requirements of retribution and deterrence. It cannot be serving that part, the relevant part of the sentence. Paragraph 35, we consider these components to be the very essence of the life sentence. First, by definition, denotes a period of imprisonment, which may variously be described as fixed, concrete, and immediately ascertainable. The only element of calculation involved is the deduction of relevant remand custody from the judicially imposed period of incarceration, and possibly any periods of compassionate release or other forms of pre-sentence release, an issue which does not arise for determination in this case. And I addressed the court on that issue earlier. Paragraph 36, and again, this is the distinction between a fixed term sentence and a life sentence. In all cases, a life sentence takes the form of a punishment which endures for the lifetime of the convicted person. And the court deals, paragraph 37, with the uniqueness of the statutory arrangements. and there was no dissent from the court's suggestion that the arrangements were exceptional or extraordinary, and they set out a provision of the Belfast Agreement, and the significant paragraph 2 that prisoners affiliated to organisations, which this is at MS 263, or are not maintaining a complete and unequivocal ceasefire, will not benefit from the arrangements. And of course, if 6 years were taken off his custodial term, he would benefit from these arrangements, and he has not complied with this. This is reflected again in the judgment of Lord Bingham in McLean, which he deals with at MS 264 at paragraph 39, about halfway through that section. But prisoners affiliated to organisations which had not established or were not maintaining a complete and unequivocal ceasefire were not to benefit from the accelerated release arrangements. Paragraph 40, he deals with the distinction between section 4.4, which deals with fixed-term prisoners and those dealing with life sentence prisoners, and makes the point that I made earlier about the relation back to 38.2 of the 1953 Act, which for your reference is at MS 809. And at paragraph 43, two notorious facts. And what the court described there about halfway through is the ensuing legislation reflected the elements of heavy political compromise. And these were offensive provisions to any victims. And again, for those reasons, should be construed in strictly narrow terms. They make the point at paragraph 46 that the Lord Chief Justice did not stated the tariff period, that's the last line of that, is stated in unqualified terms and without any exception. That's the point I made to the court earlier. And that the relevant, this is paragraph 47, the relevant part of the sentence is the judicially determined tariff. And paragraph 49, the court states about 6 lines down, the case on behalf of the department and the prisoner overlooks entirely the unmistakably bilateral nature of the unique arrangements devised by the Act. Release for the beneficiary prisoners was strictly conditional upon compliance with the statutory licence. And 4 lines further down, revocation would reflect an assessment that the non-compliant prisoner, by his conduct, had abused the trust reposed in him and would in consequence forfeit the exceptional statutory benefit conferred upon him. The conferral of a further benefit on such prisoners in the form of full credit for the period of their licensed release from prison seems to us impossible to deduce from the statutory provisions considered in their full context. We consider that this windfall, wholly unmerited in any reasonable view, could not have been intended by the legislature. And then there's a summary at paragraph 51 of the way the court deals with the arguments which were raised by the appellants. And I commend that to the court just as a summary. And I've opened up Roman numeral 4. Roman numeral 3, the court indicates that he has enjoyed the full benefit intended. Subparagraph 5 is not double penalisation. That he had forfeited the benefits of his exceptional and conditional release by his egregious breaches of licence. And
may not be double penalisation, but I think the main point was that it was doubtful penalisation. And you've been reading us a bit from 43, where the Divisional Court says there are legislative gaps. Well, normally the approach, surely, in a criminal case is that if there are legislative gaps, they are to be filled in favour of the defendant and the prisoner. But this is, you've all made so clear this is special Northern Ireland legislation, construed here by specialist Northern Ireland judges. And yet we're here, and you won't be surprised to hear that going through my mind, aren't these hugely important arguments best addressed to specialist Northern Ireland judges in the Court of Appeal?
I would normally agree with your lordship, were it not for pragmatic reasons. I'd like to simply get the case heard.
Very well. Understood.
I wouldn't depart from that.
No, thank you.
At all.
Very fair about that.
So,
Yes.
And yes, and a strong court as well. We would say the divisional court is one of the, I can't remember which one, indicated Lord Justice McCluskey and Mr. Justice Colton.
Yes.
So, I'm coming to a conclusion here.
Can I just take you back
Yes.
a step? I'm trying to understand what jurisdiction the Lord Chief Justice was exercising in fixing the 30 years, and it seems to be under Article 11
Yes.
of the 2001 order, which we have on page 781. Is that right?
It is.
Slightly curious, because although he's making the decision, he's in fact being consulted by the department, which
It's something which is dealt with in the main body of the divisional court judgment. The case of King interpreted Article 11 in such a way that would, in fact, rather than simply be...
I understand that, but it's more the language. You see, what it says there lies where the Department of Justice so on certifies if this order had been in operation at the time when he was sentenced, the court would have ordered that the release provisions would apply to him as soon as he had served a part of his sentence. So it's asking him to look at the position as it was when the original sentence was passed. And I wondered how that fitted in with your suggestion that somehow the Lord Chief Justice was saying something about what had happened since. I mean, it's, as I underread that, the Lord Chief Justice acknowledges that he's been on licence, but that's really not relevant because he's simply looking at the position as it would have been had these provisions been enforced back at the time he was sentenced. Is that right?
That is right, my lord. But he could have used the opportunity, as Lord Chief Justice Kersey then did in the Brady case, to refer to it. And it didn't. And we may not all be here if he had.
I see. Well, Lord Justice Kerr might have.
So
Anyway, that's the formal
Yes,
position. Yes, thank you.
So, last couple of points then. We say that certainty and the principle of that is fulfilled really in much, that the position taken by the divisional court is much more conducive to the principle of certainty than any other vague notion that somehow time that you spend on licence can come off your custodial tariff. And that's set out by the court in its judgment. We also say that the 98 Act should be interpreted in line with the Good Friday Agreement, and that one has to look at this in terms of encouragement, incentive to prisoners to comply with the peace agreement and the terms of it. And it is the Good Friday Agreement, it would be antithetical to that were there not something hanging over prisoners and organisations, something to encourage them for the rest of their lives, if they're life sentence prisoners, to comply, and that there should not be some kind of revolving door arrangement whereby if you get out for a period of time, it's going to come off your sentence anyway. You commit an offence such as this, go back in, but no matter what happens, you will be released in 2019. That would not be in line with the principles behind the Good Friday Agreement. There should be something hanging over the heads of life sentence prisoners.
Might it not be said that it maximises the incentive to 1998 Act prisoner to comply with the conditions of the 1998 Act if they know that by doing so they're getting credit while they stay clean, if you like, against the sentence, that the tariff element of the sentence that has been imposed against them.
Yes, indeed, my lord.
But sorry, I'm putting that as a point against you, because that would suggest that if one's trying to construe the 2001 order coherently with the policy underlying the 1998 Act, one might say that the incentive, which is regarded as a political imperative under the 1998 Act, to if people are going to be released on the 1998 Act licence, to remain free of criminal activity of various kind, is going to be maximised if they appreciate that while they remain clean, they're also getting credit against the tariff element of their sentence.
Well, it would be a greater incentive if they knew they could be called back. Yes, there is an incentive there of sorts, my lord, but there would be a greater incentive for what are heinous crimes if a larger threat hung over them, that they could be called back and required to serve the period that they have thus far spent on licence. So there is some incentive, but one should, in an extraordinary scheme, the full rigours of the law should apply. If you don't comply with it, you shouldn't get any benefit whatsoever from it.
Thank you.
And there were some hypothetical examples floated around. What if somebody towards the end of their life committed some crime? Well, the courts have taken a view in more recent years that no matter what age you are, you're subject to the full rigours of the criminal justice system. That's the first principle. Secondly, if there was an unfairness that might arise in those circumstances, there are other facilities that may be available, such as a prerogative of mercy, and the divisional court deals with that in its judgment. So, in conclusion then, we say that this is very straightforward. There is no statutory provision which indicates that you should not, when you have a tariff of imprisonment, that there should be any deduction from that in the 1998 scheme. And the most that the appellants can do is try and imply one into it. There's absolutely no policy reason why such a provision should be implied into the legislation. In fact, policy would dictate otherwise, that the normal rigours of the criminal justice system should apply, particularly when you have not complied with your part of the agreement. If there's anything I can assist the court with.
I think we've put everything to you that we wanted to put to you, Mr. Lavery. Thank you very much indeed. Mr. O'Brien? Mr. Cole.
My lady, my lords, on behalf of the Centre Review Commissioners, can I say what would hopefully be taken as some good news in this court today, in that we've listened carefully to the submissions that have been made by my learned friends, and obviously we've taken account of the written submissions. As you will understand, the Sentence Review Commissioners stand somewhat outside of this, and in circumstances do not feel it's necessary to make any actual specific oral submissions, as matters have developed, being here on a protective basis on some kind of quasi-watching brief has, I think, satisfied our interests, and we don't feel the need to take any of the court's time. We're conscious of the fact that McGuinness number 3 case has now, the judgment has been delivered in that by the court in Belfast. We anticipate that that's going to be subject to appeal by Mr. Lavery's client. So what I could say is that we suspect that it's entirely possible at some stage in the future the issues arising of a greater interest to the Sentence Review Commissioners in that case may make their way back to this court, and if they do, we will be happy to address them in due course.
But by a different route?
By a more traditional route, one might say, if I can use that Irish phraseology. So unless there's anything in particular that the court has for me on behalf of the Sentence Review Commissioners, I will sit down.
I think not, Mr. Cole. Thank you very much indeed. Thank you.
I have some brief remarks in response to Mr. Lavery's submissions. I think I've counted them as 4. I'll try to be as brief as possible. The first is in relation to the question of deductions in terms... Oh, sorry. Sorry, the first point was in relation to the question of deductions for pre-release or compassionate temporary release or other lawful release prior to the expiry of one's tariff. I think Mr. Lavery has understood that I was suggesting that the decision of the Divisional Court meant that they must be deducted. I certainly don't read the Divisional Court's decision as saying that. It specifically stated that it wasn't there to determine that, but that that question remains unresolved. And certainly we highlight the unresolved nature of the possibility that those other types of lawful release before the end of a tariff as contributing to the lack of legal certainty and as being factors which under the same principle of approach that has been commended by the Divisional Court could be approached in the same way. So I hope I've made myself clear on that point. The second point I'd like to address relates to this argument. I think Lord Carnrath noticed it about the Lord Chief Justice in setting the 30-year tariff, there being an implication that the release under the 98 Act would be taken into account, and there are 2 relevant authorities on that, one of which is in the bundle. Unfortunately, the other one isn't in the bundle, but I do have a reference for it. If we perhaps start with the authority that's in the bundle, and that's Ree King's application, and Mr. Lavery has referred to that. That's under tab 13 of the Primary Authorities volume at page 685. And that was a decision of the Northern Ireland Court of Appeal. And we see in that head note that one of the questions posed was whether materials unavailable when the preliminary sentence passed was to be taken into consideration for subsequent sentencing purposes, and it referenced the 2001 order.
13. No, she meant 11.
11, I think.
Sorry, did I say?
Yeah.
Apologies.
11.
Thank you.
So one of the factors that was considered in Ree King's application was the extent to which Article 11 requires the court to put itself in the position that it was in, and the relevant section, we say, in response to that, the Court of Appeal's conclusion is found at page 703 at paragraph 75, wherein the court determined that we are of the opinion that the legislation requires that the minimum term to be determined as if fixed by the sentencing court at the time at which the prisoner was originally sentenced as a life prisoner. Accordingly, the issue as to what is relevant to the fixing of the minimum term must be addressed in accordance with the approach which the statutory scheme has adopted, subject to compliance with Article 6 of the Convention. That was another issue raised in that appeal. There's an additional authority, slightly more recent authority, again from Northern Ireland, and that is the case of...
Does that say the same thing?
It says the same thing.
Do we need it?
We can provide a copy of that authority, but in terms it says exactly the
I
same.
mean, it's pretty clear on the wording of the order, isn't it?
Yes.
I'll then move on to my third point, if I may, which is in relation to the overture remarks of the Lord Chief Justice Kerr, as he was then, in the case of Brady. And Mr. Lavery has referred to the fact that the Divisional Court referred to our muted reliance on it. Well, certainly the overture remarks were viewed by the Department as being not necessarily a definitive statement of the law, but as encouraging them in their understanding of what the process should be applied to those in Mr. Stone's position were. And we have accepted the Divisional Court's analysis of the strength of Brady, or the lack of strength of Brady, as it were, in its use as a binding authority, but that doesn't mean that it's not correct in how it got there. So the only other point that I would then like to make is in relation to the submission made by Mr. Lavery as to whether it was important to have the tariff period or the custodial period hanging over the life prisoner's head, hanging over his head for the rest of his life. Well, it's clearly not a revolving door policy, because if one has one's sentence, one's licence revoked and is brought to prison, they still have to serve the remainder of that custodial sentence. And what will be, of course, remaining as an incentive to good behaviour is not only the remainder of any unexpired tariff, but of course the more individualised and perhaps more onerous terms of the licence period that would be imposed pursuant to the 2001 order. So we certainly agree with the thesis suggested by Lord Sales, to the effect that it would certainly be a greater incentive to a life prisoner to know that the longer that he runs down his tariff, as it were, by maintaining good behaviour and adhering to the licence conditions under the 98 Act, the more likely that he will, of course, remain well behaved and not wish to breach those terms of that licence. Unless there's anything further, those are the only remarks I have.
Could I just ask, and I may have missed it, was Mr. Lavery sort of faintly suggested that one might have got here via the leapfrog procedure? Have you commented on that?
I haven't commented on that.
I mean, did anyone give any thought to whether there was a possibility of doing that?
We did give thought to it, but we weren't sure at the time whether Mr. Lavery's client would have agreed to it. So it seems
He says they would.
we didn't raise it with him. We just assumed that in our written statement of case that we wouldn't propose it, because we thought we would be on very shaky grounds in proposing to the court that we would embark on a leapfrog appeal out of time that required the consent of all parties. But perhaps,
it seems to be, if the alternative is this
yes.
seems to be a complete waste of time, it would be rather.
But of course, at the time of the submission,
I'm asking now. I'm
realised,
simply saying, what is there to stop the parties now going back to the Divisional Court and inviting us to hang on a bit before we give our judgment and see if they can get it to us by that route?
Yes, well, from that perspective, we have absolutely no objection to that, and if it's a pragmatic way of resolving this, we would be very keen to avail of it.
I'm expressing no view. I'm just trying to find some way in which we can get over what seems to be a very unfortunate procedural hurdle.
Do we have the statutory provisions concerning leapfrog in?
Well, it's sort of set out partly in
Mr. Lavery gives it to us, doesn't he?
Yes, yes.
Yes.
I mean, it's obviously not something we can pick up now, but I suspect we would be if the parties were to go away and come back to us and say, well, this works, and Divisional Court's might be happy. Myself,
Well, in principle, it's certainly something that the department would be very keen to avail of if that was the decision of the court.
Thank you.
Response to login.
Unless there's anything further. Thank you very much.
Thank you.
Lords, just hopefully a few short points from me. Can I start by picking up on my Lord Carnwath's point? We had also thought about the leapfrog provisions, but I think there may be a fatal difficulty with that. It's dealt with in Section 12 of the Administration of Justice Act, and Section 12.4 provides a time limit. So the application has to be made immediately after judgment, but the judge can grant a certificate up to 2 weeks after that, or at any other time if permitted by rules of court. And there's no provision in the rules of court, so it seemed to us that the 2 week time limit was a statutory time limit with no provision for extension.
I mean, it doesn't come within the general power to extend, which I'm sure there is in the rule.
It doesn't seem to, my lord. This issue was raised long after that 2-week period had expired. Had it been so easy to simply go back, so I'm very happy to be corrected by anyone else, but I think that's the difficulty. So that's section 12.4. And I should say, if the court is interested in looking at section 12, it is amended for Northern Ireland purposes by section 16, which also requires in Northern Ireland, but I think not in England, the consent of all of the parties.
I couldn't hear that, I'm afraid, Mr. Schofield.
Sorry, my lord, section 16 amends section 12. That's the leapfrog provision for Northern Ireland. We require the consent of all parties, which I don't think is a requirement in England and Wales. So the substantive points on the appeal, my lady, my lords, my learned friend began with the 1998 Act. He says it should be given a narrow construction. We say that's not to the point, because section 4.4 shows that the policy of the Act is that sentencing time runs during a period of release on licence. Now, my learned friend is right to say there's no analogue of section 4.4 for life sentence prisoners. But the reasons for that are very simple. Firstly, a life sentence does not expire. And all section 4.4 says, really, for determinate sentence prisoners is, while you're on licence, your sentence may expire. A life sentence doesn't expire. Now, a tariff does expire, of course, but at the time the 1998 Act was made, we didn't have the tariff procedure, which only was introduced in 2001, 3 years later. So at that stage, we were governed by the old scheme under, I think it was section 23 of the Prison Act. One didn't have a legally fixed tariff. The key point on the 1998 Act we submit is that my learned friend, Mr. Lavery, with respect, had no convincing answer to the question posed to him by my Lord Wilson. Why should the fixed sentence prisoner who breaches his licence get the extra benefit? If they do, why, similarly, should a life sentence prisoner not receive that benefit also? And my learned friend, we respectfully say, didn't have a persuasive answer to that. Ultimately, he said, well, a life sentence is for life. Well, that's right, yes. But a tariff is not. And this case is concerned with the expiry of the tariff. Article 6.6 of the 2001 order, 3 questions we say that haven't been answered by my learned friend. He says it's not designed to deal with prisoners who are lawfully at large. That's to say, who are outside the prison on a lawful basis. Why does it not deal with them? Well, that's because the general position is that time spent counts towards the sentence. It doesn't need to be dealt with because that's the general rule. Second question, why is Article 6.6 needed in relation to time spent outside the prison unlawfully? Why does that specifically have to be discounted? No answer to that. Because if his case was correct, that provision would be totally unnecessary. Third question, why is there no similar provision to allow an exceptional case of a prisoner who is lawfully at large to avail of the time spent outside prison? Again, my learned friend can't explain why there is that anomaly. None of those arise on our interpretation. My learned friend then moved on to deal with temporary release. Mr. Smith's affidavit sets out a range of temporary release schemes which may be availed of pre-tariff expiry. Learned friend Mr. Lavery says, well, they may or may not count towards tariff expiry. And we say that's contrary to the case which is made by the respondent and contrary to the approach of the divisional court. They've both taken a fairly absolutist line that in respect of the tariff period, the full period must be served in custody. That's my learned friend's case at paragraphs 4, 21 and 39, and the divisional court's ruling at paragraphs 34 and 48. But in our respectful submission, neither my learned friend nor the court below provide any principled basis for saying that those periods of release should be treated differently from a period of release on licence under the 1998 Act. Now, ultimately, what Mr. Lavery said was, well, it's really to do with the length of time. A period of temporary release is likely to be for a very short period. Well, firstly, that's not a proper reason in principle, but secondly, A release on licence under the 1998 scheme could be for a very short period of time if there was a licence breach shortly after release, but also temporary release under, for instance, a working out scheme could also be for quite some time, and the court will see what Mr. Smith has said about that in his second affidavit. So the other answer is, well, this is really all about retribution and deterrence, but we say that that does not require each night, indeed each hour of the sentence to be served in prison. It is no part of the policy of the 2001 order that the tariff period should see the prisoner spend what might be referred to as the hardest time possible in prison. And then, as we've also said in our written case, retribution and deterrence is also, of course, a feature of determinate custodial sentences, expressly so in England under the 2003 Criminal Justice Act. But there's no suggestion that a fixed-term prisoner who is released on temporary release has to have the end date of their sentence recalculated, and we say that there's no principled basis for treating life sentence prisoners differently in respect of their tariff. Learned friend then said there's no provision in any of the statutes to say that when time starts to run for a sentence, it doesn't stop. We accept that that's right, but what you'll have seen from our case is that where the contrary is the case, where time is paused and the currency of the sentence does not continue, that is specifically provided for, and we've given examples of that in paragraph 20 of our written case. Finally, my learned friend says the hypothetical examples which were provided, we give an example of someone sentenced to a very long tariff who's released 2 years into their sentence, as many of these prisoners were, and then very late in life when their tariff would have expired, they breach their licence, or they're said to have breached their licence. Are they then expected to be brought back in at that stage and to start their whole tariff minus 2 years? We say that that can't possibly have been intended by Parliament. And my learned friend says, well, and the court below say, well, that can be dealt with by the royal prerogative of mercy. 2 questions we asked about that. Firstly, why should such a prisoner be dependent on the royal prerogative? But secondly, if my learned friend and the court below were right, that that person has not satisfied the requirements of retribution and deterrence, why on earth would the royal prerogative of mercy be granted in their favour? And then Article 6.6, you know, a much more simple remedy would simply be to say that the department can direct that that time should be taken into account. And as I've said, there's no clear answer as to why that provision is not made in Article 6.6. But the court knows our answer to that. If our interpretation is correct, it's not required. I'm very grateful for your indulgence, and unless I can be of any further assistance, those are our submissions in reply.
It would appear not. Thank you very much indeed. Thank you to everyone, and thank you for timetabling this hearing so that we could deal with both aspects on one day. It would have been very inconvenient if we'd had to split the two up, so we're most grateful to you all. You set us quite a puzzle, and we will now go away and try and solve it.